Change of name. 2023. In re. André Pierre Harris for change of name. 2023. Court of Appeal, 2nd District, Division 8, California. In re. André Pierre Harris for change of name. B322152. Decided August 16, 2023. André Pierre Harris, in proper, for petitioner and appellant. André Pierre Harris is the name on Harris's birth certificate. Harris applied to the trial court in March 2022 to change his name to Minko Hasseh El Bey. On the ground that Harris has outstanding warrants, the trial court denied Harris's petition. We affirm because there was no abuse of discretion. See in re. Ross, 1937, 8 Cal.2d 608, 609, 67p.2d 94. Before the hearing on his petition, Harris published his request 4 times in a newspaper of general circulation, as required by Code of Civil Procedure Section 1277, subdivisions A2, A, and A3. Had his request for a change of name been for purposes of gender affirmance, under Code of Civil Procedure Section 1277.5, subdivision B, effective January 1, 2019, publication would not have been required. The trial court evidently ran Harris's name through law enforcement records and found warrants. It issued a tentative opinion stating it planned to deny the petition on the ground that petitioner has an outstanding warrants. Its final order stated that, having heard from petitioner, the court was adopting its tentative ruling and the petition was denied without prejudice. The petitioner may reapply. Harris's appellate record does not describe his court hearing. Nor does this record elaborate the number or nature of the warrants that were the focus of the court's ruling. By statute, it was proper for the trial court to check law enforcement records when considering Harris's petition to change his name. The California legislature has directed courts to use the California Law Enforcement Telecommunications System, CLETS, and Criminal Justice Information System, CJIS, to determine whether a name change applicant must register as a sex offender. If a court is not equipped with CLETS or CJIS, the clerk of the court shall contact an appropriate local law enforcement agency, which shall determine whether or not the petitioner is required to register. Code Civ Approc. Section 1279.5, subbed F. By passing this statute, the legislature sought to ensure people required to register as sex offenders cannot change their names to frustrate the registration requirement. If this law enforcement check reveals the applicant has outstanding warrants, it is not an abuse of discretion for the trial court to deny the name change until the applicant rectifies the situation. Arrest warrants are written orders signed by a magistrate, commanding the arrest of named people. For Witkin and Epstein, Cal, Criminal Law Pretrial, 4th edition 2023, Issuance and Service of Warrant, Section 18, see Pen. Code Sections 814 through 816. Bench warrants may issue for bail defendants who do not appear. For Witkin and Epstein, Cal, a Criminal Law Pretrial, Supra, Section 18. Arrest and bench warrants serve the public interest by bringing people to court who should come to court. Because warrants name the wanted person, a name change could frustrate their function. People wanted by law enforcement should not be able to use the legal system to avoid obligations to the legal system. Harris argues this is a case of mistaken identity. He cites page 18 of the record, which ostensibly is a request for judicial notice he filed in the trial court. This request, however, begins with a set of factual assertions in the nature of a declaration or a brief. Harris avers he is a living soul, the spiritual man made from the dust with the holy breath of the Creator YHWH, God, Genesis 2 verses 4-7. He is a native-born Muyuar, native to this land. CFUS v. Hillman, 7th Circle 2015, 610 Federal Acts. 574, 575-578, unpublished. Conviction affirmed despite Habib Jimenanu Abay's argument that the government failed to prove he pretended to be a diplomat from a foreign country because the Muyuar Republic did not exist. City of Shaker Heights v. El Bey, 2017, 86 NE. 3D 865, 866-867, Brandon Prophet El Bey claimed to be a national of United Washita de Dugdamoundia Muyuar. Court rejected appeal, commenting that many courts have rejected similar challenges to convictions based on sovereign citizen or sovereign nation arguments. Harris's request contained other assertions, as well as a request that the court take judicial notice of submissions Harris made to the Federal Securities and Exchange Commission and the Federal Trade Commission. These submissions are not relevant to Harris's petition to change his name. The trial court did not abuse its discretion by failing to discuss this ostensible request for judicial notice. On appeal, we cannot adjudicate a factual question about mistaken identity. The trial court invited Harris to resubmit his name change application. The trial court is the proper forum for initial resolution of Harris's factual claim. Harris asserts a procedural violation. He argues no one objected to or appeared to oppose his application, so the trial court was obligated to grant his petition. He writes that the court denied his name change petition in favor of a third-party interloper from another state without requiring the party to file written petition objecting to the name change, and without requiring the party to appear in court to testify with first-hand knowledge to claims of controversy against the name. The record contains no evidence about a third party. We interpret Harris's objection to mean that he is familiar with a warrant issue, that he believes someone in another state is responsible, and that he argues the trial court must approve his petition if no one from that other state appeared or filed objections in this California trial court. This argument is mistaken. The statute does allow people, in writing or in person, to be heard and to appear in opposition to name changes. For instance, a court denied one Eugene Weingand's petition to change his name to Peter Lorre. The famous actor Peter Lorre protested the petition by the unknown Weingand, who was no relation to Lorre but while working as a real estate agent had passed himself off as Lorre's son. Weingand bore a physical resemblance to Lorre, and affected a manner of speech similar to Lorre's, but had no family connection with the name Lorre or with any name sounding like Lorre or Lorre. The court held it was no abuse of discretion to deny this name change petition. Weingand v. Lorre, 1964, 231 Cal. App. .2d 289, 291 to 294, 41 Cal. RPTR. 778. Certainly people can appear to oppose a name change. If no one appears, however, the court is not required to approve the change. The statute does not mandate approval if no one has registered written or oral opposition. The provision about sex offender registration proves this. That provision implicitly authorizes a court, on its own, to deny a name change. Whether other people do or do not raise objections is immaterial. Harris levels a different but invalid attack by suggesting the court unethically engaged in the practice of law by representing a third-party interloper. It is possible for judges to violate ethical principles by undertaking their own factual investigations into a case being tried to a jury and then calling and questioning their own witnesses before that jury. See Ryan v. Commission on Judicial Performance, 1988, 45 Cal. .3d 518, 536 to 537, 247 Cal. RPTR. 378, 754 p.2d 724. This trial court did nothing like that. This court's conduct was proper. A statute mandated its approach. The court shall use law enforcement databases to determine whether the name change applicant must register as a sex offender. Code Civ Approc. Section 1279.5, subbed. F. Harris's charge that the court acted unethically is in error. Harris suggests the court improperly relied on hearsay by considering the warrants against him. Harris forfeited this objection by offering no timely or specific objection in the trial court. See Evid. Code, Section 353, subbed. A. Harris filed a motion in this court to compel a finding in his favor, arguing that we failed to schedule timely oral argument and that no brief opposed his appeal. We deny this motion. Oral argument was in the normal course, and the absence of an opponent does not imply decisive merit. See Cal. Rules of Court, Rule 8.220, A2. On July 20, 2023, Harris filed another document titled Letter and Notice of Mandatory Judicial Notice of the Indian Civil Rights Act of 1968 referenced as Title II of the Civil Rights Act of 1968. This document is a combination of a declaration asserting facts, a brief asserting legal arguments, and a request for judicial notice of a federal statute. We do take notice of this statute, but it has no bearing on the merits of this appeal. We disregard the aspects of the document that make factual assertions and legal arguments. The trial court and not the appellate court is the right place for factual presentations. We have not requested, and we do not accept, further legal briefing. Disposition. We affirm the order and do not award costs. Kenneth Michael Mead, et al., defendants. Case number 1:21 CV01184, TNM. Memorandum opinion. According to the complaint here, state and federal law enforcement officers stopped a truck belonging to Tribal Nations United Ministries, Tribal Nations, an alleged tribal organization. The officers seized the truck and interacted with a tribal marshal employed by Tribal Nations. About 2 weeks later, those officers again saw the marshal at another traffic stop of a Tribal Nations member. The officers ultimately arrested the marshal for reasons unexplained by the complaint, and a Las Vegas court ordered him detained. The court upheld its detention order at a preliminary hearing about 1 month later. Proceeding pro se, Hasseh El Bey sued the main players in this saga, ostensibly on behalf of the detained marshal. The defendants moved to dismiss the complaint on many grounds, most saliently because El Bey lacks standing to assert the marshal's rights. The court will grant those motions and dismiss the complaint. The court notes at the outset that El Bey's complaint is difficult to follow and decipher. He leaves out many factual details underlying his allegations, including anything about his role in the alleged incidents. More, he delineates certain names with 2 colons, example, Hasseh El Bey. ELBEYV, Meet et al. Document 34. Dockets.justia.com. 2. And inserts random brackets into common words, example, false, imprisonment and excessive bail. See compel. Paragraphs 9, 53. And El Bey fails to mention by name any statute, law or constitutional provision. Instead, he continuously asserts violations of due process of law and equal protection of law. See ID paragraph 53. Notwithstanding these infirmities and distractions, the court seeks to identify the key incidents in his complaint and to construe his allegations under the proper source of law. El Bey describes himself as tribal chief of Tribal Nations United Ministries, a group comprising tribal members who can trace their bloodlines to the original native tribes in America. ID paragraphs 1, 4-5. Tribal Nations employs tribal marshals who observe, record, report, protect, and serve tribal members, tribal property, and tribal affairs. ID paragraph 10. Christian Reginald Craig is one of those marshals. 1 C ID paragraph 9. This case arises from events in Las Vegas. According to the complaint, 3 plainclothes law enforcement officers stopped a truck belonging to tribal nations. See ID paragraph 12. The complaint does not say how Craig came to the scene, only that he arrived while wearing his tribal marshal uniform and identified himself to the officers. See ID paragraph 16-18. Despite Craig's efforts, the officers refused to give him the truck. See ID paragraph 20. Allegedly, the officers had no warrant for the stop. See ID. About a fortnight later, the same officers stopped another tribal nations member at a shopping mall parking lot. See ID paragraph 25. One officer allegedly pointed his gun at the tribal member, who called Craig to the scene. See ID paragraphs 22-24. Craig wore his marshal's uniform and again identified himself to the officers. See ID paragraphs 26-27. The complaint does not describe. 1. According to records attached to the complaint, Craig's original name was Reginald Vincent Craig. See compel, X1 at 2-3. The complaint says that Craig legally changed his first name to Christian Reginald. See compel. Paragraph 7. 3. What happened next, but 2 of the officers eventually arrested Craig, apparently without a warrant. See ID paragraph 30. Those 2 officers were Kenneth Meade and Scott Nielsen, both of the Las Vegas Metropolitan Police Department, LVMPD. See ID paragraph 39. The 3rd officer from the first traffic stop was later revealed to be Blake Voigt, an FBI agent. See ID paragraph 41. A state judge, Eric Goodman, set bond for Craig at $300,000 and detained him until payment of that amount. See ID paragraphs 31, 48, 51. A month after that, Craig appeared for a hearing at which Meade and Nielsen testified. See ID paragraph 43. The complaint provides few details about that hearing beyond allegations that Meade and Nielsen falsely testified about tribal nations and its members. See ID paragraph 46. Craig also stated that no evidence presented violates his civil rights and asked for release from jail on his own recognizance. ID paragraphs 49, 51. Judge Goodman refused. See ID paragraph 51. Craig remains incarcerated. See ID paragraph 37. El Bey then filed this complaint. He alleges that Craig's false imprisonment and excessive bail is a gross violation of due process of law and of Christian Reginald Craig's equal protection of law. ID paragraph 53. El Bey sues almost anyone who had any involvement in the case, including Meade, Nielsen, Voigt, Judge Goodman, and prosecutor Eckley Keech. See ID paragraph 50. In addition, El Bey sues the relevant employers of those men, including LVMPD, the City of Las Vegas, Clark County, the District Attorney's Office, the State of Nevada, and the FBI. El Bey alleges that those entities are all agencies who must operate humane ways, to preserve life and liberty, a duty that El Bey says they failed to meet in Craig's case. ID paragraph 52. 4. El Bey also specifically alleges that Nevada, Clark County, and LVMPD acted without lawful authorization. See ID paragraph 45.2. El Bey requests injunctive and monetary relief. He asks for the immediate release of Craig from prison and for an order that the defendants cease all wrongful trespass and violations of due process inflicted on Craig. ID paragraph 56. El Bey also asks for money damages against the defendants who orchestrated and neglected to prevent the alleged violations of due process suffered by Craig. ID. After filing his complaint, El Bey began to serve the defendants. That process has been something of an ordeal. El Bey first failed to serve all defendants within the timeframe allowed under the Federal Rules of Civil Procedure. The court granted him an extension of time to do so, warning that unserved defendants could be dismissed from the case. See Minute Order, July 30, 2021. Although El Bey used that extension to serve some defendants, 3 he failed to properly. 2. Because all defendants other than the FBI acted under color of state law and allegedly violated constitutional rights, the court construes the complaint as being brought under 42 U.S.C. Section 1983. 3. Some defendants maintain that, even with the extension of time, El Bey did not properly serve them. See LVMPD-DEFS. Motion to dismiss at 2, ECF number 10-1, Clark CNTY. DEFS. Motion to dismiss at 2, N.1, ECF number 15. And the state of Nevada has never appeared despite El Bey filing on the docket some returns of service that might signify proper service. See ECF number 26. For purposes of this opinion, the court assumes that El Bey has properly served all remaining defendants. For that reason, the court will grant in part El Bey's outstanding motion for judicial notice, see ECF number 23, which asked the court to take judicial notice that he had properly served certain defendants. The court will grant that motion as to service of process on Keech, Judge Goodman, and the state of Nevada, but not as to the FBI. Assuming proper service of process on those defendants, however, does not prevent the court from dismissing El Bey's complaint for lack of standing. See Dominguez v. DIST of Columbia, 536 F, Sup. 2D18, 23-25, DDC. 2008. 5. Serve Voight or the FBI under Civil Rule 4, I. The court thus dismissed Voight and the FBI from the case. See Order, ECF number 27. See also Order on Motion to Vacate, ECF number 30. Meanwhile, the other defendants submitted motions to dismiss the complaint. See ECF numbers 8, 10, 15. El Bey has responded. See ECF numbers 19, 20, 25.4. Those motions are now ripe. 2. The defendants move to dismiss El Bey's complaint on various grounds, including under Rule 12, B1, for lack of standing. Standing is essential throughout a case and, as a jurisdictional matter, may be raised sua sponte by the court. Cicero v. Mnuchin, 857 F.3d 407, 415, DCCIR 2017. See also Penkoski v. Bowser, 486 F. Sup. 3d 219, 227, DDC 2020. To satisfy his burden to prove standing, El Bey must offer evidence showing that he has suffered an injury in fact that is concrete and particularized, and actual or imminent, not conjectural or hypothetical. Lujan v. DEFS. Of Wildlife, 504 U.S. 555, 560, 1992. This injury must be fairly traceable to the challenged action of the defendant and not the result of the independent action of some third party not before the court. ID, cleaned up. And it must be likely, as opposed to merely speculative, that the injury will be redressed by a favorable decision. ID at 561, cleaned up. When ruling on a motion to dismiss under Rule 12, B1, the court must assume the truth of all material factual allegations in the complaint and construe the complaint liberally, granting the plaintiff the benefit of all inferences that can be derived from the facts alleged. AM. National Insurance Company v. FDIC, 642 F.3d 1137, 1139, DCCIR 2011, cleaned up. And plaintiffs bear the burden to establish by a preponderance of the evidence that the court has jurisdiction. For in El Bey's responses, he includes motions to strike for various reasons the defendant's motions to dismiss. None of those reasons is legitimate. El Bey's motions to strike will thus be denied. 6. Including the irreducible constitutional minimum of standing. Lujan, 504 U.S. at 560. The court may consider such materials outside the pleadings as it deems appropriate to resolve the question whether it has jurisdiction in the case. Grand Lodge of Frat. Ord of Police v. Ashcroft, 185 F. Sup. 2D9, 14, DDC 2001. El Bey proceeds without counsel. This triggers special solicitation for him. A document filed pro se is to be liberally construed, and a pro se complaint, however inartfully pleaded, must be held to less stringent standards than formal pleadings drafted by lawyers. Erickson v. Pardis, 551 U.S. 89, 94, 2007, cleaned up. More, the court must assess a pro se complaint in light of all filings, including filings responsive to a motion to dismiss. Brown v. Whole Foods MKT, GRP, Inc., 789 F.3d 146, 152, DCCIR 2015. But pro se plaintiffs must still adequately plead their complaint consistent with the Edicts of Ashcroft v. Iqbal, 556 U.S. 662. 2009, and Bell Atlantic v. Twombly, 550 U.S. 544, 2007. See Afferton v. EDC off. Of Mayor, 567 F.3d 672, 681-82, DCCIR 2009. The court thus does not accept as true legal conclusions or threadbare recitals of the elements of a cause of action, supported by mere conclusory statements. Yellen v. U.S. Bank, National Association, 301 F. Sup. 3d 43, 47, DDC 2018, quoting Iqbal, 556 U.S. at 678. 3. El Bey's complaint is noteworthy for what it does not allege. At no point does El Bey say that the defendants deprived him of anything. Instead, he asserts that the defendants unlawfully seized the tribal nation's truck, unlawfully arrested Craig, falsely imprisoned Craig, and detained him with excessive bail. For simplicity of analysis, the court will separate the challenge to the truck seizure from the other challenges about Craig. 7. A. In his challenges about Craig, El Bey alleges that the defendants violated only Craig's rights. That presents an immediate standing issue for El Bey. A plaintiff generally must assert his own legal rights and interests, and cannot rest his claim to relief on the legal rights or interests of third parties. Worth v. Selden, 422 U.S. 490, 499, 1975. So El Bey normally would be unable to assert violations of Craig's rights. Certain plaintiffs have standing, however, to protect a third party's rights when 1. The plaintiff has suffered an injury in fact sufficient to give him a concrete interest in the proceeding, 2. The plaintiff has a close relationship to the third party, and 3. There is some hindrance to the third party's ability to protect his own interests. Powers v. Ohio, 499 U.S. 400, 411, 1991. El Bey has met none of those requirements. See Oolaki v. Obama, 727 F, Sup. 2D1. 23, DDC 2010, T. He burden is on the plaintiff to establish that he has third-party standing. Not on the defendant to rebut third-party standing. Cleaned up. First, El Bey never alleges that he has suffered any injury, all allegations center on injuries suffered by Craig. This alone justifies dismissal. Second, even if El Bey suffered an injury in fact, he does not have a sufficiently close relationship with Craig. To show that relationship, the identity of interests between Craig and El Bey must be close enough to make El Bey an effective advocate for Craig's interests. Lepelletier v. FDIC 164 F.3d 37, 44, DCCIR, 1999. The court knows of no authority holding that a tribal chief has the necessary relationship to assert a member's rights, rather than those of the tribe itself. That is unsurprising. Confidential or contractual relationships have most often been found to support third-party standing. Turner v. U.S. Agency for Globe. Media, 502 F. Sup. 3D 333, 361, DDC 2020. 8. One could argue that Craig as a tribal marshal has a contractual employment relationship, but even then, his contract would be with tribal nations, not with El Bey. See Compel. Paragraph 9, noting that Craig works as tribal marshal for tribal nations. And although some courts have found a close relationship based on a plaintiff's supervisory authority over third parties, see Turner, 502 F, Sup. 3D at 361-62, the complaint gives no details on El Bey's alleged role as tribal chief and his responsibilities there, including the supervision of marshals. Third, even if El Bey can meet the first two requirements, he has not shown any genuine obstacle that prohibits Craig from protecting his own interests. CAM. IMIG. Lawyers Association v. Reno, 199 F.3d 1352, 1362, DCCIR 2000, quoting Singleton v. Wolf, 428 U.S. 106, 116, 1976. Craig clearly knows his conditions of detention, none could argue that he is likely unaware of the alleged deprivations he has suffered. Lepelletier, 164 F.3d at 43. More, Craig has already shown the ability to challenge those conditions. He represented himself at his hearing before Judge Goodman and asked questions of various witnesses. See Compel. X1 at 11-22. Someone capable of self-representation in that adversarial arena can file his own complaint protesting his detention and the circumstances that put him there. 5 To be sure, filing a complaint from jail is not easy. But it is not impossible. And normal burdens of litigation do not present such a hindrance that Craig must rely on El Bey to assert his rights. AM. IMIG. Lawyers Association, 199 F.3d at 1363-64. Nor is there any evidence that Craig requested El Bey's help. El Bey therefore has not shown that he has standing to challenge the alleged violations of Craig's rights. 5 Indeed, Craig apparently has hired counsel, see Compel. Paragraph 37, further obviating the need for El Bey's advocacy. 9. Basia El Bey's standing to challenge the seizure of the truck likewise suffers from multiple flaws. For starters, the truck apparently does not belong to him. Documents attached to the complaint show the truck as registered to tribal nations. See Compel. X1 at 4-5, ECF No. 1-1, tribal nations then should be the one to seek compensation for the seizure of its property. See, example, Common Cause v. FEC, 108 F.3d 413, 416, DCCIR 1997, stating that an organizational plaintiff may have standing to sue on its own behalf to vindicate whatever rights and immunities the association itself may enjoy. El Bey therefore has not shown that he himself suffered some threatened or actual injury resulting from the putatively illegal action. Worth, 422 U.S. at 499. He thus cannot invoke the court's jurisdiction, his alleged leadership role in tribal nations notwithstanding. 6 See Sierra Club v. Morton, 405 U.S. 727, 738, 1972. He party seeking review must himself have suffered an injury. More, even if El Bey could argue that he suffered a personal injury from tribal nations' alleged injury, his complaint fails another element for standing. For a plaintiff to have standing, his alleged injury must be likely to be redressed by the requested relief. Daimler Chrysler Corporation v. Kuno, 547 U.S. 332, 342, 2006. Here, none of El Bey's requested relief will lead to the truck's return or compensate for its alleged unlawful seizure. El Bey requests relief only from alleged due process violations inflicted on Craig, including for Craig's immediate 6. The complaint provides little detail about the structure of tribal nations and whether, like federally recognized tribes, it has a defined group of leaders who can authorize a suit by tribal nations. Cf. Timbisha Shoshone Tribe vs. Salazar, 678 F.3d 935, 938, DCCIR 2012. But even accepting his leadership, El Bey still sues under his own name and thus must allege injuries against himself as the complaining party. Worth, 422 US at 499. True, a judgment in his favor might collaterally benefit the organization he leads, but that does not excuse him from the requirement that he must allege a personal injury from the truck seizure. ID. Whether he leads tribal nations is therefore irrelevant for standing purposes. He is the named plaintiff and must establish his own standing. 10. Release from jail. Compel. Paragraph 56. An order to release Craig from jail would not redress any alleged injury suffered by tribal nations over the seizure of the truck. Nor would money damages for the various alleged violations of Craig's due process rights compensate tribal nations for the seizure of the truck. In sum, El Bey requests relief only for Craig's alleged injuries. At no point does he request any relief to compensate or otherwise address tribal nations' injury from the truck seizure. He therefore has not established his standing to challenge that seizure. 4. For these reasons, El Bey's motion for judicial notice will be granted in part and the defendant's motions to dismiss will be granted. 7. That dismissal will be with prejudice. The court may dismiss a complaint with prejudice when any possible amendment of the complaint would not survive a motion to dismiss. See James Madison Limited v. Ludwig 82 F.3d 1085, 1099. DCCIR 1996, Carty v. Author Solutions Incorporated, 789 F. Sup. 2d 131, 135-36, DDC 2011. Here, El Bey could not amend his complaint in any non-futile way. As discussed above, El Bey is not even the proper plaintiff to sue. Tribal nations would need to bring its own suit, which would require a new complaint, not merely an amended one. And even if El Bey's amended complaint alleged his own injuries, all the events giving rise to the claim occurred in Nevada. 28 U.S.C. Section 1391, b. Venue would therefore be improper in this district anyway, and the court would grant a renewed motion to dismiss on that basis. Thus, El Bey cannot save his complaint. 7. Because the court finds that El Bey lacks standing under Rule 12, b. 1, it need not consider defendants' various other justifications for dismissal. See BYD Company Limited v. All. 4 a.m. Manufacturing, F. Sup. 3D, 2021 WL347, 2386, at *4, N.3, DDC August 6, 2021. 11. A separate order will issue. Dated, October 26, 2021 Trevor N. McFadden, USDJ. October 26, 2021. 15 hours 57 minutes and 24 seconds -04 foot 00.